What we did not do back in 1964 is pass a law that says starting tomorrow, everybody in the country has to treat each other nice. What we did do is create a system of statutes, which created a system of penalties, which impacted business. I've got three general performance objectives for the course today. And they are that by the end of the day, you'll have a plain English understanding of today's employer and employee legal issues. You'll understand the logic behind smart employment practices, and you'll know management strategies that generally keep your employer out of trouble. And yet, by the 1980s, the courts began to take a very active role in interpreting these laws. They began to take a very active role in interpreting something called public policy, the statutes that we were talking about yesterday. Now, businesses are smart. If you have a choice of paying an attorney $150 an hour to the next quarter-hour increment for any issue that shows up, or paying somebody in-house to be the low-cost provider of legal advice for the routine issues that commonly surface, what are you going to do? And 1 year later, President Johnson signed into law something called Title VII, or the Civil Rights Act of 1964, as a living monument to the then dead President, John F. Kennedy. Now, as originally conceived, Title VII would create four protected classes of people, that is, classes of people that were protected from discrimination in the employment arena, those classes being race, color, national origin, and religion. Now, there was a senator. Now, as we roll forward in time, what happens? With the close of the Civil War, the Industrial Revolution begins to take off in earnest in this country. We have people moving from the farms to the cities. We have more people working under one roof than ever before. And with that, we need to take a fresh look at the employer-employee relationship. And to fill the gap, there's a legal theorist by the name of Horace Wood, who in 1877 wrote something called a treatise on master and servant. Note the language, note the thinking at the time. A treatise on master and servant. In it, he defined something called employment at will, the idea that an employer could hire or fire someone for a good reason, a bad reason, or no reason at all. And an employee could leave a company for those same reasons. Now, it took 30 years and a Supreme Court case out in San Francisco in 1908 for that to become the guiding doctrine in employer-employee relationships. And yet, since that time, employers have largely viewed themselves as employers at will. Employers who... And the very first thing I want to talk about is this notion of employment at will. Now, again, this is the theory that employers can hire or fire someone for a good reason, a bad reason, or no reason at all. And that is still true, unless you're an employer with a union, which means you're an employer with a contract, or you violate one of 7 exceptions to employment at will. Jim Vance, first of all, and I'm an unusual guy to be standing up here for a variety of reasons. Foremost, I think, is that I let an 18-year-old choose my college career for me, and I majored in chemical engineering. Oh, wow. And I actually worked as a chemical engineer for about 6 years. I was a licensed professional engineer. And then I discovered something when I got into engineering. What I realized was that engineering was one of those professions where you have to relearn everything every few years because your technical knowledge has a half-life of 3 to 5 years. And I asked myself what didn't have a half-life, and what doesn't have a half-life is leadership, human development, communication, these kinds of things. And in my off time, I began to study that, and over time got a background in that. and then migrated over to the people side of engineering. And from there, I had the opportunity to jump ship from a Fortune 100 company to a small organization that was growing very rapidly. If no attention was paid to HR tomorrow, would anybody care? Would anybody complain? If you're sitting over there going, well, I'm not sure, you have work to do. You with me? All right, because you have. I can tell you the symptoms of a poor interview process. And they are, you start comparing candidates to each other instead of what you really want. And you have to bring somebody back because you can't make a decision. There's a whole lot of companies that say employees are our most valued asset until the economy goes south and now they're a variable cost. But if you treat them like a variable cost, then what goes out the door? So the idea that we have to manage this comes into our consciousness. And you could really add to this, the next level beyond this is HR needs to be transformative within our organizations. Meaning that if you look at one of the great problems in our business today, it is the intelligent use of human resources and the intelligent use of technology. If technology is used poorly, it can make us inefficient that much faster. And it can consume our lives, and if we manage by the numbers, we can unwittingly undermine our standards if we're not careful. So anyway.